Is it possible for one spouse to keep all of the money and leave the other with nothing during a divorce? Yes, but that is highly unlikely to happen. The presumption is in divorce that marital property be divided equally unless 1. There is some compelling equitable reason for an uneven distribution, and 2. The trial court is willing to go to the trouble of explaining its unequal division in commendably detailed written findings. This is from Davis v. Davis, paragraph 11, 76 P. 3rd, 716, 2003 Court of Appeals, citing the Bradford v. Bradford case. In Utah, the principle is explained well in this part of the Fischer v. Fischer case, volume 505, Pacific 3rd Reporter, page 56 at paragraphs 23 and 25 from Utah Court of Appeals decision of 2021. I'll summarize it here. In dividing the marital estate in a divorce proceeding, each party is presumed to be entitled to 50% of the marital property. But rather than simply enter such a decree, the court should then consider the existence of exceptional circumstances and, if any be shown, proceed to effect an equitable distribution in light of those circumstances. Thus, once a court makes a finding that a specific item is marital property, the law presumes that it will be shared equally between the parties unless unusual circumstances, memorialized in adequate findings, require otherwise. An unequal division of marital property is only justified when the trial court memorializes in detailed findings the exceptional circumstances supporting the distribution. Although the district court has broad latitude in equitably distributing the marital estate, it cannot unequally divide that estate unless it memorializes in adequate findings the unusual circumstances that justify doing so. Couldn't be clearer. Here are some examples of Utah case law of an unequal distribution of marital property. Riley v. Riley, volume 138, Pacific Reporter, 3rd, page 84, paragraphs 28 and 29. From the Utah Court of Appeals, 2006, citing to Davis v. Davis, 76 Pacific Reporter, 3rd, page 716, paragraph 12. In Davis, the trial court allowed each party to retain the retirement and pension accounts in his or her name. The court explained any perceived disparity by noting that the husband had the present and future ability to ensure adequate retirement funds while the wife did not. In addition, the court noted that the wife had contributed significant amounts to marital obligations that the husband had not. Like the court in Davis, in the present case, we conclude that the trial court made sufficient factual findings to support its conclusion that there were exceptional circumstances warranting a seemingly unequal distribution of the parties' retirement accounts. Here, the trial court found that husband benefited in his personal happiness and career opportunities throughout the course of the marriage. The family coordinated its activities to further this goal. The family relocated from Alaska to Utah in order for husband to obtain an education in his chosen field. Wife liquidated her premarital assets, including investment funds, which would have a current value of $124,012.91 to further husband's career goals. Wife contributed approximately $275,000 to $300,000 more than husband over the course of the marriage. As a result of becoming a commercial pilot, husband had a very substantial increase in income. Wife's income has remained relatively unchanged. While it is legally possible for one spouse to receive the entirety of the marital estate, such an outcome in Utah is rare and permitted only where exceptional circumstances exist and are thoroughly documented in the court's detailed findings.